from the Shannon. This measure relates to customer due diligence, measures for persons that can be described as politically exposed persons. In general, these measures must be carried out before a person opens an account. However, a bank can allow an account to be opened without first carrying out the measures, as long as no transactions are carried out on the account. So we've got an account open, we don't have any dealings on the account. The amendment extends that exception to all financial institutions, and again, it's in accordance with reading of the directive.
Amendment number 2 agreed. Amendment number 2 is agreed. Amendment number 3 and 4 are related, will be discussed together. Minister.
3 and 4 together, Count Corley. These are technical amendments. They relate to the conditions under which a designated person can rely on a third party to carry out anti-money laundering measures on its behalf. There's a requirement currently that the person is satisfied that the third party will provide them with appropriate documentation and relevant information. These amendments clarify that it's not necessary if certain circumstances apply, including that the person and the third party are part of the same group. And again, I would point deputies to Article 28 of the directive, and this is in accordance with that.
Is Amendment 3 agreed? Amendment 4 is Amendment 4 agreed? Yes. Amendment 5, Minister. 5 and 12 are related and can be taken together.
5 and 12, Count Corley. The purpose of these amendments is to remove a requirement to report to An Garda Síochána and the Revenue Commissioners all transactions relating to what is known as, and I quote, high-risk third country, unquote. High-risk third country is one which is not considered to have adequate controls in respect of money laundering purposes. The requirement is considered to be unnecessarily broad when combined with the European Commission's new designations of states as high risk. And the view here is that this would be unduly burdensome for An Garda Síochána and also for the business entities involved. I know we discussed this at an earlier stage of proceedings, but since the bill was published and having regard to discussions that took place both within the House and outside, the amendment is considered desirable and I'm proposing it. But can I say, Count Corley, that there's already something of a requirement to report any transaction that is suspicious. This is a general requirement. In that regard, almost 25,000 reports were received by An Garda Síochána under this requirement last year. So the bill also contains an obligation to apply due diligence of an enhanced nature in relation to customers from high-risk third countries. So I wouldn't like deputies to think that we were in any way diluting or weakening the legislation. So accordingly, I'm making the proposal as in the amendments.
Amendment 5, therefore, agreed? Agreed. Amendment 6, Minister.
Amendment 6 relates to the power of An Garda Síochána to direct that documents and records are kept beyond what is the normal period of 5 years, the 5-year retention period. This inserts a safeguard that the direction must be given in writing.
That agreed?
Can I propose that?
Agreed. Amendments 7 and 8 and 11 are related and can be considered together. Minister.
7, 8 and 11 together. These amendments transpose part of Article 47, paragraph 2 of the 4th Directive. That requires that managers, as well as beneficial providers of gambling services, are persons that are regarded as fit and proper persons. The amendment inserts 5 new sections requiring anybody who is a person directing a private members gambling club or who is a beneficial owner of such a club that they must hold a certificate of fitness, and if they don't, it will be an offence for any person to engage in activities or business without holding what will be the certificate of fitness. The rest of the provisions set out in the procedure for actually set out the procedure that will be in place for applying for this certificate of fitness. The application may be made to An Garda Síochána. If the person doesn't live within the state, it's made to the minister. Of course, a certificate may be refused if a person has been convicted of certain offences. The certificate will last 3 years. There's a provision for an appeal to the district court in respect of a refusal to grant the certificate. Amendments 7 and 8 are consequential amendments to the numbering of a different section. That the House will be aware of the wider work on gambling that the government is undertaking. We have approved the setting up of an independent gambling regulator. My colleague Minister Stanton has chaired a working group on reforms in this area that has recently completed its work. And while those broader proposals are being developed, the provisions here now will allow us to ensure that persons involved in this sector are persons that can be regarded as both fit and proper and appropriate. We do that in respect of our own national legislation, but also so that our EU obligations are complied with in MIT.